think that silence means we're ready to begin. That combined with 1:30. Thanks everybody for coming. This is the meeting of the Civil Service Merit Board for September 13th. And let's start with calling and roll. Scott Schubel here. Stephanie Taylor.
Present.
Okay, Mark Duke.
Here.
And Jane Roberts.
Here.
I'm Bill Lyons and I'm here, so we have a full contingent today. The first item is the approval of the minutes of the previous meeting that was held on August 9th.
Make motion.
Second.
We have a motion and a second. Any discussion? Okay, all those in favor of approving the minutes signify by voting aye.
Aye.
Opposed? No? Okay. Minutes are approved. So we're now at the report stage. Any reports involving litigation? George?
Nothing this from the law department, Mr. Chairman.
Okay.
Nothing to report, Mr. Chairman, thank you.
Thank you, Mr. Winchester. Okay, and now let's hear from the Civil Service Staff report. Go ahead.
Sure. I'll make this pretty brief. These are mostly updates on updates. Update on grievance activity. We actually had we had a step 3 grievance that was holding for the hearing, and that was actually resolved prior to the step 3 hearing without the necessity of a hearing. So that's always good when they're able to come to a resolution prior to a hearing. We had a step 2 that was resolved at the step 2 level, so the employee and the department head worked that out. So both of those were positives. We always want to avoid a hearing if possible. It's best if folks can work these things out at a more informal level. So that was a success. Our eSkill contract for our online testing software has been finalized. It will be. This is the last year that the contract could be renewed as is, so next year we will actually have to do a new contract. So I have a note in my calendar to make sure I start that process very early so that we have plenty of time to get through that process and get that in place for the future. Our standard contract has also been finalized. That is the contract to update our fire promotional exams, and we do that regularly. At least every couple of years we update those exams and give them some fresh content. So that process is underway. I'm almost complete with the exemption updates in PeopleSoft. As I let you guys know last time, I've been working with IT, basically just remapping what was in there. What was in there was not useful information. It wasn't labeled in a way that anyone would even understand what those fields might be. What we are 99% completed with is having a panel in PeopleSoft where anyone that has that access can go see if an employee's position is classified or unclassified, and if that employee is classified or unclassified, because those aren't always the same. And we have one more step that I was working on with IT this morning, and I would expect probably by the end of the day, that's going to be clear and complete. And going forward, that can simply be looked up in PeopleSoft. So that was a tremendous accomplishment, and I am so thankful for IT for all the hard work that they've done to get that done. I think we've gone live. If we haven't gone live, we're very close to going live with a new city intranet. It allowed each department to really expand the content that we had in the capacity. So we have a lot of additional content on our intranet page, resources for employees, forms, PowerPoints that they can watch to see how something works, what's the grievance process, rather than just having to read a piece of paper. They can go watch a PowerPoint, that will walk them through it, provide all the documents. So that's a tremendous resource for employees. So we were happy to see that getting up and running. And I had a couple of meetings with some of the HR staff that they had requested, and they were absolutely great and productive. One was to meet with all of their HR generalists to talk about the job analysis process, because there's a piece that they do and there's a piece that we do, and we need those to be very cooperative and work together. And they have been great to ask us what we need and what we need from them in that process. So that was a great meeting. And also, as Mary Margaret gets up and running as a new talent acquisition coordinator, we met to just discuss sort of our respective roles, mine with recruitment specifically, and then how her role can support that. in a bigger picture sense. So both of those were really great meetings. Happy to work with them on those things. And that is it for the staff report.
Okay, do we have any questions on the staff report? Thank you, that was thorough and helpful. HR report.
Started. Good afternoon, board. Good to see you all, and I'm gonna be quick because I'm gonna ask, I see that one's over. That was hooked in there. I'm gonna ask Devin Lyons to come in and speak on the subject that I think is at everybody's attention today and the conversation. I wanna make sure that you all know as we start this conversation and we look at this, on August 31st, Devin brought before what was requested from the mayor to the city council in a workshop. And what I asked to do is after the workshop is to bring the same information to you all so you can have an understanding and a discussion about the information that was presented at the workshop. And I want to make sure I say to you, as a 35-year veteran in HR, I have been working in nonprofit, for-profit, government. I have taught at multiple universities and colleges from an HR perspective. After reading this document, I must tell you that I fully support the information, and MTAS, which is a government entity, has given and provided information as well. I think as we look at this and as we talk about this information, I think that you will find, even though historically things have been done one way, just because something has been done one way doesn't mean that there's not opportunities for change and transformation. And so as we look at this, I want you to think about best practices. I want you to think about efficiencies and how we can operate in a method from the city of Knoxville that is not sporadic or pieced out, but how do we do this? I'm very excited about this, but the one piece that I want to make sure I say, because the question, the mayor met with the 3 employee reps this morning, and one of the questions that came up was, is this going to get rid of civil service? Let me say, absolutely no. There's no expectation, no thought to eliminate civil service. And I want to make sure, as this is being recorded and it's being said, there is no thought to eliminate civil service. Civil service is a protection that every employee should have. Every employee should have that ability to have the civil service protections. What this proposal that I think Devin will talk to you about is about how do we do this and how do we work with best practices, looking at what other government entities and municipalities have done, and how do we work more efficiently and how do we work better. Again, just because it's the way it's always been done doesn't mean that you don't change and you don't make modifications. So I would like to bring forth Devin Lyons on my behalf and speak to the committee, speak to the council. Thank you.
Thank you. And if you all don't mind, I'm going to assume the hot seat up here so I can actually see you all. Thank you for your time this afternoon, and to be as respectful as I can of that time, I'm going to go through this as quickly as I possibly can. I'm going to hit the highlights, but think of it as more of a Cliff's Notes version of the report. I believe that you all have a physical copy of the report that hopefully you've had a chance to review, or if you haven't already, will have that chance in the coming days and weeks. There's a lot of information in there, and I want to be as thorough as I can, but just hitting the highlights, all right? So by all means, if you all have any questions, that is at least in part, one of the reasons why I am here today. So feel free to ask me any questions that you have about the content of this report. I will tell you that I made the mistake of doing a bunch of yard work this weekend, and I'm now afflicted by allergies. So tell me if I start to trail off. I'll try not to cough too much, but let me know if you can't hear me. I'll try to do my best to speak up. As Director Drummond just mentioned, this is the second of 2 parts of a report to City Council that was actually requested by City Council. The impetus behind this was Resolution R-263-2021, which requested a report from the mayor regarding, as it was termed in the resolution, policies regarding racist and sexist practices of the city. On November 30th of 2021, the mayor submitted her report to council discharging the obligation that was asked of her by city council. And in her report, she made a detailed summary of existing city policies. And she made certain recommendations for how city policies can be improved. And one of those recommendations was to retain MTAS, the University of Tennessee's Municipal Technical Advisory Service, to do a benchmark survey and identify peer governmental entities, primarily those that had dual HR and civil service systems, to determine how they organized their equal employment opportunity protections. And using that data, the mayor's report also recommended that outside counsel be retained, which is me and why I'm here before you today, to specifically look into three things. The first is to identify the appropriate organizational placement of EEO enforcement functions. And as we'll talk about in a moment, that is a very confusing issue historically with the city to know exactly who or what is the enforcement authority for EEO protections. That was the first ask. The second was to review City Code, Chapter 15, Article 2, Division 2. That is the human relations chapter of the code that details anti-discriminatory practices as are codified in Knoxville City Code. And then finally, in light of those two recommendations, the follow-up would be look at the administrative rules of the city. Can those be revised in some way to help ensure that our employees are being best protected and that we are in alignment with what peer cities and peer counties are doing in this regard? So the report that you all have in front of you contains 4 primary sections. The first is, again, a summation of what the city currently does to effectuate its EEO protections. That's a summary of obligations through city charter, city code, administrative rules, civil service merit board rules, etc. The second section is a pretty in-depth historical analysis. And I'll admit that when I began research and drafting this report, I did not anticipate going down this rabbit hole. But I found, obviously I would say this because I wrote it, I think it's very interesting. I would highly recommend that you take a look. It is lengthy, but I think it's very, very important for us to consider the context of what the city has done over, I think I go back to the charter of 1945. So what the city has done over the past 80 years to get to where it is today. And that's important not just to better explain why we are where we are, but also to give interpretive guidance about what the charter actually requires. For any of you who may have taken a gander at Article 10 of the city charter, which is the Civil Service Merit Board and Personnel System article, there's plenty of questions that the language of that article can prompt. And I think it's best understood through the interpretive lens of what the drafters of Article 10 were going for when that article was drafted and approved by the voters of the city of Knoxville. So that's an important first step in this project because the city charter, irrespective of what other municipalities and governmental entities may do, the city charter puts forth the gutter guards, if you will, for what the city of Knoxville can do relative to any of its powers and duties, but in this instance, relative to EEO. So we have to establish what the charter actually permits and requires before then moving on to what is section 3 of the report, which is analyzing the benchmark data from peer cities as surveyed by MTAS to determine what those municipalities and counties do relative to EEO enforcement. There's a summary there in section 3, and then taking all of this data within the context of what our charter requires, and then distilling that down into any recommendations that I thought prudent based on the benchmark survey results is what you'll find in section 4 of the report. So if you think of it, the 4 sections are basically, what does the city currently do? Why does the city currently do what it does? What do other peer governments do? And where does the city go from here? So regarding section 1 of the report, I don't want to belabor this. Again, it's all contained in the report, and I would ask that you read it when you have the opportunity. But there's an assessment of city charter, city code, the administrative rules, state and federal law that actually sets forth many EEO protections, and the Civil Service Merit Board rules. And the good news from that is that the city is compliant with all EEO requirements. And in fact, as I've asserted in the report, the city goes above and beyond by imposing its own additional requirements to ensure that it is meeting EEO protections throughout various departments, agencies, boards of the city. But for the purposes of our meeting today, since I'm here before the Civil Service Merit Board, I thought that I would focus on the charter and code provisions that related to this board, to the powers and duties that this board has pursuant to charter. But again, if you have other questions, I'm happy to address those at the end of this presentation. There are two key provisions that come into play relative to this board's EEO powers and duties. And those are contained in Charter Section 1003F, specifically the powers and duties of F8 and F11. Under F8, the Civil Service Merit Board is empowered to hear allegations of discrimination in hiring, transfer, or promotion. The board can also hear allegations relative to neglect of duty or other violations of merit system principles. That's again 1003F8. The other key charter provision is 1003F11. That sets forth this board's power to develop a program to provide for equal employment opportunity. And relative to the charter, that's really all the guidance that we have, at least as it pertains to EEO. Moving to the code, however, there's additional guidance. In Code Chapter 15, City Council has set forth a non-discrimination clause for all city contracts, which the law department incorporates. All of the protected classes that are set forth in state and federal law are codified in city code through Chapter 15. And then specific to issues relating to the Civil Service Merit Board, Code Section 15-53 states that the responsibility for carrying out and enforcing the provisions of this division, meaning the Anti-Discrimination Division of the Code, shall be placed with the person designated by the mayor to carry out the functions and purposes of this division, who shall be an appointed member of the Civil Service Board staff. And currently, there is one such position that is an appointed position of the Civil Service Board staff, and that's your executive secretary, Dr. Hackett. So, pursuant to city code, not charter, but city code, the responsibility for enforcing EEO is set forth in Section 1553 with an appointed member of the Civil Service Board staff. Section 15-54 then sets forth all the powers and duties that that position as enforcing officer can undertake. There are many of them, but the key ones are, as you might expect, that the enforcing officer is authorized to administer and enforce the provisions of Chapter 15, to investigate any charges of unlawful employment practices, and then to protect persons from discrimination in employment on all grounds covered by this division, again, meaning Chapter 15. So that's where we find ourselves after an analysis of charter and code. And what's interesting to me is that in looking at other areas of city code, there are quite a few contradictions and conflicts that are baked in as we currently stand today. I think that part of the reason we find ourselves here is because over the years, the city has focused more on compliance with the EEO protections to ensure that employees are best served and their concerns are best met, rather than looking at a cohesive big picture of what the city as a whole does in relation to EEO. And as best I can determine, this report may be the first attempt, and only attempt, at looking at that big picture and trying to determine how all of these different layers of the onion fit in with each other, and can they be improved. So the result is that EEO requirements are scattered throughout various places of city code, which has prompted organizational confusion. And I want to give just a few examples of this so you know what I'm talking about. Section 15-53, which I just mentioned, it states that the enforcing officer of the EEO shall be an appointed member of the Civil Service Board of staff, right? Well, that conflicts with Charter Section 1003, which states the powers and duties of the Civil Service Merit Board, in that the Merit Board is not given any enforcement powers relative to EEO functions pursuant to the Charter. More concerningly, it directly conflicts with Code Sections 2-3 and 2-111. I realize I threw out a lot of numbers at you, and I apologize for that. But again, all these are contained in the report. You're happy to, I would request that you actually consult and read these provisions for yourselves. But 2-3 sets forth the mayor's powers and duties, which includes responsibility for enforcement of EEO. 2-111 sets forth the powers and duties of what's called the Office of Community Relations. That's at least the term that's given that office in the code. That is not the colloquial name by which that office is currently identified. It's now the Community Empowerment and Safety Department. But pursuant to code, EEO enforcement should flow through the Office of Community Relations, not the enforcing officer as named in Section 15-53. So there's an irreparable conflict already in code relative to those EEO enforcement powers. And if you dig down into the administrative rules, there are additional conflicts. In Administrative Rule 1.06, which is the city's harassment policy, the harassment policy permits the civil service director to investigate any complaint of harassment that comes in to the civil service office. The civil service director is then authorized to prepare a summary of findings and recommendations, which are then given to the mayor, the director of law, and the department head of the affected employee or employees, which will then follow with any disciplinary action that may be prudent from the department. This also conflicts with Article 10 of the Charter, in that Article 10, again, permits the merit board, not the executive secretary or a civil service director, but the board, to hear allegations of discrimination, but only with respect to hiring, transfer, and promotion. The Charter is very clear about that. It is not an unbridled authority to hear allegations of discrimination broadly. Yet that is what we see if you look at Administrative Rule 1.06. The Civil Service Office can investigate any harassment complaint. The same is true with Administrative Rule 1.07. This is the city's workplace violence policy. This is basically the same issue I just addressed with the harassment policy. The only reason that workplace violence is mentioned is because workplace violence is actually defined in the policy as harassment or intimidation. So they flow in one another. And then looking at Civil Service Merit Board rules, Article 3 of the board rules sets forth the Equal Employment Opportunity and Affirmative Action Plan, discharging the power and duty that the board has under 1003 F11 in the Charter. And Article 3 of the board rules states that the city shall establish, implement, and maintain an EEO plan. Again, recognizing that it is the city's responsibility to implement and maintain or enforce the EEO protections within city policy. And the board recognizes in Article 3 that it possesses the power only to develop a program to provide for EEO, not to enforce the same. So Article 3 conflicts with Civil Service Merit Board Article 17, in that Article 17, as an investigatory rule of the board, again provides the Civil Service Director with unlimited authority to investigate any discrimination complaint that is made to civil service. So again, there are conflicts that are baked in a number of ways here, no matter which area of authority you happen to examine. So that's a problem. The good news is that I did not find any evidence of this confusion detrimentally impacting or negatively impacting any investigation that was performed when a complaint was actually made. But it is confusing. I try to place myself in the role of an employee who has a complaint. Depending on what type of complaint I may have, I can be ushered to as many as 5 different departments or offices. And the only way I would know that is by either contacting the appropriate office or then possibly examining city administrative rules or Civil Service Merit Board rules and in different chapters of the same, trying to figure out what tranche my complaint fits in. So if I have a complaint relative to disability discrimination, let's say, I would not contact any of the departments that we've discussed so far. I would need to know to go to the Housing and Neighborhoods Department and find the ADA coordinator, Ms. Cook, and contact her with a disability discrimination complaint. If I had a sexual harassment complaint, I would go to either civil service or the law department and file my complaint there. And depending on which department I file my complaint with, different steps in the process would then be undertaken. Or if I had a Title VI complaint, I would be directed by code and by city policy to the Office of Community Relations, which is actually called the Community Empowerment and Safety Department. And then on an interim basis, because of employee turnover in that office, those functions are now being performed by the Human Resources Department. So it's a tangled web of expectations for employees. And for that reason, there are many opportunities for the city to streamline that process so that employees' complaints can be effectively heard and resolved expeditiously, but also accurately and better serve the complainants who have their complaint. So why do we have all of these conflicts? Why is the code and the administrative rules, why are they organized the way that they are? And that's where Section 2, this historical analysis, is key. And you're welcome in that I promise I'm not going to be going through all of this. I'm just going to hit the takeaways, if you will. Although, again, I do find it quite fascinating. I hope you'll read it. But this report took me back to, as I mentioned, the Charter of 1945 to present, code sections that dated back to 1962 to present, law director opinions, Civil Service Merit Board meeting minutes, Charter Review Commission documents, Knoxville News Sentinel articles, City Employees League meeting minutes. It's a large scope of an investigation, which explains why some of this report is so lengthy. But from going through all of that, you'll find that before 1981, which is when the charter was revised to effectuate Article 10, the Civil Service Board article and Personnel System article, before that time, in spite of the Civil Service Board existing for some 40 years prior, EEO functions were exclusively performed and enforced by the mayor, the city administration. There was no Civil Service Merit Board, or board as it was originally called, no civil service involvement in EEO whatsoever. In 1981, at a what was reported at the time to be a surprising passage of a referendum, Article 10 was enacted. And Article 10 expanded the powers and duties of the board. But importantly, the impetus behind that expansion of powers and duties had nothing to do with equal employment opportunity protections or the enforcement of the same. It was in fact expanded because of a subset of employees that were disgruntled. They believed that they were underpaid. They believed that with the dire financial straits that the city was in at this time in the early 80s with the World's Fair on the horizon in 82, that there were layoffs that were being openly discussed. There were property tax increases being discussed, parking rates increasing, certain insurance premiums they were going to have to pay for. So there was a subset of employees that were unhappy about this. And that is what really prompted a renewed expansion of civil service powers to serve as a check on the mayor's ability to effectuate those concerns. Not EEO concerns, but those employment-related concerns. And upon passage of Article 10, it's interesting to me that the very first meeting, I believe it was January 3rd of 1981, the very first meeting of the Civil Service Merit Board, everyone was confused. That we have the charter that states what it states, but how to interpret that was unclear to the board. It was unclear to the mayor. And ultimately, the Civil Service Merit Board and the mayor at the time, Mayor Tyree, struck what's referred to in the meeting minutes as an agreement, where they intended to reduce their understandings of Charter Article 10 to writing through an MOU. And as best I can determine, that MOU was never actually executed. And that prompted years of confusion about what specifically Article 10 provided to the Merit Board in terms of its powers and duties. And when disputes arose, which they did repeatedly then, the consistent legal opinions from the City Law Department, which included at the time the actual drafters of Article 10 of the Charter that provided the board with its powers and duties, the consistent legal opinion from those sources, which are objectively the best sources, is that the Merit Board did not have enforcement authority over EEO functions. It could hear allegations relative to discrimination in hiring, transfer, and promotion. It could develop an EEO plan, which, as codified later, is in conjunction with the city. But it does not have enforcement authority as a board. There are multiple examples of those legal opinions that are provided in the report, and that are the operative sections thereof are actually embedded within the report, so you don't have to flip through some 60-odd appendices. But that, to me, is, to the extent there is a dispositive answer or an objectively correct answer on the interpretation of Article 10, it is by the drafters of the same, and that was their opinion. And unfortunately, over time, these legal opinions sometimes have been misunderstood, sometimes have been disregarded because of the needs of the day, the pressing issues of the time. And really, I think, as has even been expressed in the Civil Services report to City Council, based on this resolution that prompted this project, some of these functions have ended up just becoming civil service functions by default, because for a period of time, there was no personnel or HR department of the city. So who else could perform these functions? But importantly, now that the city has reestablished the HR department, we can return to what the charter actually sets forth in its powers and duties of the board, and those bifurcated duties of the board versus the personnel system of the HR department. And that segues nicely, I think, into Section 3, which is the MTAS survey results. MTAS surveyed governmental entities throughout the country. Their goal, as I mentioned earlier, was to determine how similarly situated governments organize and address their EEO requirements. And they actually reported to me that there are so few governments that employ tandem civil service and HR systems, especially to the degree that the city of Knoxville does, that they actually struggled to complete the survey. But they were able to identify numerous entities and provide their policies and their organizational structure that they provided to me. And I won't go through this entire list, but some of the governmental entities include New Haven, Connecticut, Fort Lauderdale, Florida, Boston, Massachusetts, Sacramento, California, Atlanta, Georgia, a couple of counties in New York, Morristown from here in Tennessee, Anderson County here in Tennessee, and Memphis. And in examining what all of these governmental entities do with respect to EEO, there are several takeaways, because several of the functions that these governments perform are uniform among them. Almost all of these governmental entities have uniform enforcement of EEO functions by the HR department of that particular government, with advice and recommendations of legal counsel. If the governmental entity is large enough to have a law department, that's the entity that performs that role, or if they're smaller, then they have an outside counsel that performs that task for them. But it's always HR. Within those HR departments, the staff of the HR departments are typically designated to review specific types of complaints, depending on what type of complaint it is. There's a particular staff member who may be the point person on discrimination complaints, and a different staff member in HR who may be that person for harassment. But it's all handled within the trained HR staff of the HR department of that governmental entity. Some HR departments of these entities have a specific position, particularly again the larger ones, a specific position to oversee and coordinate all EEO compliance. So while that particular position may not be the person who is the frontline individual who would actually do an investigation or resolve a complaint, there is an individual who is tasked with being the coordinator or the person who is responsible, the position that is responsible for EEO compliance within that governmental entity. And basically this is my term. This is not a term that I've seen used, but as I summarize this, to me it reads like the HR department of these governments is a clearinghouse. So any type of EEO-related complaint or issue would flow into the HR department, which makes this a very simple process to explain to employees and for employees to understand and comply with. And then at that point, depending on what type of issue is implicated by the complaint can be either directed to the particular HR position that handles that type of complaint, or in the city of Knoxville's instance, where the Civil Service Merit Board is given charter authority to hear allegations of discrimination relative to hiring, transfer, or promotion. The HR department can then kick that complaint over to the Merit Board for the Merit Board's resolution, so that the Merit Board is able to discharge its charter obligation to hear those types of allegations. So again, my term is a clearinghouse, for lack of a better term. And this, from those takeaways from what other governments do, it really highlights the difficulties in the city's current processes, where the city's EEO compliance is of more of a scattered nature, as we've discussed. But it also demonstrates that because there are so many different individuals in current city practice that are tasked with roles in the city's EEO program, that despite what Chapter 15 of the Code says, which Section 15-53 would put the appointed member of the Civil Service Board staff as the enforcing officer for all of those various functions, that's not what's currently happening. Even though the Code says that, that's not what the city is currently doing. The city has an ADA coordinator that handles ADA-related issues. The city has a Title VI office that handles Title VI-related issues. It's not all vested with one person. From that, it really, to me, makes clear that there are certain recommendations, which this is Section 4 of the report, certain recommendations that the city can undertake to better align its practices with peer cities, and to make a more cohesive structure of an EEO program that benefits employees through organizational efficiency, through increased communication, through by limiting the individuals who are performing these types of EEO-related investigations, to ensuring that those investigations are carried out accurately and in an accountable fashion. And it really just increases the effectiveness of the city's EEO program as a whole. And those recommendations, as I previewed a second ago, are basically to create a clearinghouse in the HR department of the city. With the reestablishment of the HR department, this has mooted the need for the executive secretary as the appointed member of the Civil Service Board to serve as the enforcing officer for all things EEO. That is HR's task. That is not what the charter provides for the Civil Service Merit Board. And that's what other governmental entities do. They place those functions with HR. This may require, as I told City Council during the workshop, this may require the allocation of additional resources to the HR department. Specifically, it may require the creation of a deputy director of sorts to serve in that EEO officer role, where that position can then coordinate and oversee all of the EEO compliance within the city's program. And it will also require, in order to effectuate this, will require a revision to existing city code. As I mentioned, the code is already in conflict with itself in Chapter 15 and in various other places relative to the Office of Community Relations. So another recommendation that I've made in this report is to engage in a housekeeping measure to ensure that what the city actually does and what is the best practice for the city is what is codified, instead of having these antiquated code provisions that are not currently utilized still present in city code. The piggyback move from that would be to then expressly vest the powers of enforcement of EEO into the city's HR department. That would entail a revision to Code Section 2-392, which is sets forth the powers and duties of the HR department. And importantly, to although it would not necessarily have to do this, but to ensure the protection of the merit board's powers and duties as set forth by charter, one of my recommendations is to include in the code section relative to the HR department a codified requirement that the HR department notify the Civil Service Merit Board regarding any allegations of any persons on matters of discrimination in hiring, transfer, or promotion, which by Charter Section 1003 F8 is the power and duty of the Merit Board. The EEO position and program within HR should specifically include responsibility for Title VI. As I mentioned earlier, that is currently codified to be placed within the Office of Community Relations, but again, as part of a wholesale clearinghouse approach to HR, that should be placed within the HR department. The city's Title VI compliance plan as well should be revised. It's been a while since that's been examined. That should be revised to ensure that it is up to date and that it accurately reflects this organizational structure of the city. The same is true for the city's ADA coordinator. As I mentioned, ADA is currently located within the Housing and Neighborhoods Department. That too should be gradually reorganized within the HR department. And then one thing that's particularly troublesome to me is that the administrative rules, while they cover a very wide area of EEO compliance and do quite a good job of that, they also have a scattered approach to where all these different provisions are located relative to harassment or ADA compliance. So one thing the city can do is consolidate all of the EEO policies that it has into one chapter of the administrative rules. So it's kind of a one-stop shop for employees. If they have a complaint of any sort relative to EEO, they can open, instead of flipping through multiple administrative rules to find what rule may apply to their situation, they've got one location in the administrative rules where all of those policies and those procedures are located. And then in Code Section 15-57, this is the code section that sets forth the non-discrimination provisions. It's generally a blanket non-discrimination provision for all of city employment, but it sets forth the protected classes that adopts the protected classes that are set forth in state and federal law and in judicial interpretations of state and federal law. By having those protected classes mentioned in various locations throughout city code, administrative rule, or other policy, the city is building in potential for error, where some protected classes may not be included in this policy. Or, as we even see in Civil Service Merit Board Article 3, that article does not include all of the protected classes of the city simply because it has not been revised in quite a while. And protected classes have changed since that rule was revised. So keeping Section 15-57 of the code as the one authoritative location where all of those protected classes are identified will ensure that we're not missing any, basically. But that is the one authoritative location for those protected classes. Administrative Rule 1.06, this is the harassment policy. I've also recommended that this harassment policy be revised to clarify that all harassment is prohibited, not just sexual harassment. And if you've read through Administrative Rule 1.06, while it does address all forms of discriminatory harassment, the bulk of the rule is tailored towards sexual harassment, and particularly the examples that are given therein are related to sexual harassment instead of other forms of discriminatory harassment. So revising that policy would certainly provide additional clarification to employees who have a discriminatory harassment complaint that may not be of a sexual nature, and providing examples of what that kind of complaint may look like. Greene County, New York, and the City of Sacramento are two governmental entities that I thought did an excellent job of providing detailed, thorough policies that check the box for what the EEOC, the federal agency that has a role in enforcement of this, what they look for in policies. And that is to provide specific examples so that any employee can clearly understand what is permitted and what is not permitted. So revising Administrative Rule 1.06 to better explain that is another recommendation that I have. And then to dovetail that with Administrative Rule 1.18 relative to the city's IT acceptable use policy, to ensure that regardless of medium in which any allegation of harassment may take place, that it's still covered under the harassment policy. So just because some individual or some coworker allegedly harassed me through Facebook, that's still prohibited conduct pursuant to city administrative laws. And then finally, with the reestablishment of HR and the recommendation of making HR the clearinghouse for all of these EEO complaints, revising any department-specific policy that previously directed complaints to the civil service office or specifically to the law department, revising those policies to ensure that we again have a cohesive, congruent structure where any complaint is sent to HR, which will then usher that complainant or send that complaint to the right direction. That would be advisable as well. So that's the fairly quick summary of the report. As I mentioned, there is considerably more detail in the written document that I would recommend you take the time to read through if you haven't already. But at this point, I'm happy to address any questions you have or if there's any other discussion.
Let me, before we get into the questions, sort of want to see how, maybe get the sense of the board, how we want to proceed, because we have, under new business, a report by Mr. Winchester, which I take it will address the subject matter from a different perspective, maybe it's safe to say. And so we, I know we're consuming all of this great amount of information right now. So, we could hear from both and ask some questions, but we're not at a point of resolving anything other than just becoming informed today, and learning, and say there's a massive amount of info. So as we look forward to hearing from Mr. Winchester, and I know Ms. Roberts had her hand up, I would just like to ask one kind of procedural question, and then we can discuss how to go from here, whether we go right and talk or get into Q&A separately. Hopefully, though, we'll realize, I think we have a possibility of resolving anything today. We don't really have an item to resolve for us anyway. The resolution asks the mayor and her staff to work with Human Resources Director and the Director of Civil Service and the Merit Board to study and make the report to City Council, which would seem to imply some involvement during the preparation of the report prior to its being delivered. And of course, we're now meeting after the presentation to the City Council. So would you address the involvement of the Civil Service Board and Director, and for that matter, the Human Resources Department in the preparation as outside counsel? Because when the city asked the mayor and her staff, and then of course they decided to go contract with you as an outside counsel to prepare this. So apparently you did not work, as I understand it, or didn't consult during this. I wonder if you would address.
I'd be happy to, thank you. So first, regarding the language of the resolution from City Council, that language of involving the Merit Board and discussing those issues with the Merit Board was a responsibility that the city discharged through its report that it provided to City Council in November of 2021. At that time, I was not involved, but my understanding is that the city did, in fact, interact with the Civil Service Merit Board relative to that report. I believe Civil Service, at the direction of the board, prepared its own report, which was given to the mayor that summarized Civil Service's take on those issues. And then that report ultimately was sent to City Council independent from the mayor's report as called for by the resolution. So
this is not that.
This is not that report. That's exactly correct.
That's not really clear. So
that's right. So the scope of my role in this process, after all of that occurred, was to independently come in as retained solely by the mayor, and from an independent standpoint, examine what does the charter require? What do, in working with NTASC, what do other governmental entities do to effectuate their EEO programs and discharge their obligations? And it was important to me to maintain as much of an independent perspective in this process as I could. And for that reason, you're correct. I did not directly engage with the Merit Board in the preparation of this report. But that being said, with the extensive research and review of documents that I did engage in, I reviewed civil service merit board meeting minutes where these issues were discussed, even recently relative to 2021. I reviewed meeting minutes where Mr. Winchester gave his opinions on these particular charter provisions and code provisions and the interpretation of the same. So even though I did not interface directly with the Civil Service Merit Board, that is not to suggest that I did not have a working knowledge of what the board's position on these issues had been historically. But at the end of the day, as I mentioned, to ensure that the work product as set forth in this report was as independent and objective an analysis as I could perform, that's what I did. And that's what you have in front of you.
Well, why don't we, I know you had a question, Shane, and have that question, and maybe we can talk about, do we want to get into some extensive discussion now, or do we want to hear from Mr. Winchester first? And we'll just leave that up to the board, but we'll ask your question.
Sure, thank you so much. And I do appreciate this very thorough compilation. I have read through it, and like Dr. Drummond, I'm also a human resources professional, so I really want to highlight this is the population that we're talking about to better serve our city employees. And through all of this information, a lot of red tape to cut through, I definitely agree that there needs to be some streamlining so that employees know whoever they're going to speak to. That's maybe one of the few stops that they actually need to take instead of questioning, where is everything at in the process. So there's definitely a need for streamlining within that. And also just reviewing, like you said, with the kind of crisscrossing over what powers CSMB has in this too. I definitely am not comfortable making any votes regarding, any changes in any of this process now until it's reviewed by City Council coming up. So that's really all my comments that I have for that part.
Does anybody else have any comments now, or did you like to make, or would you like to hear from Mr. Winchester and have a little discussion of what any points, or I would just throw it open as to how anybody would.
Will y'all be there at the city council to make a presentation for the Civil Service Merit Board? Or is that part of?
We haven't been notified or asked or, I will tell you this, at the workshop meeting that Vicki advised, Dr. Heckler advised me of the day before, we attended it.
I was there with you.
You were there, and of course, city council members said, well, y'all consulted with the civil service. We'd like to hear what they're going to say, but it was clear that we had not seen this report at all. As a matter of fact, Vicki contacted, and not being critical, and I'm not suggesting anybody has done anything wrong.
No, of course not.
But we've been waiting 18 months to 20 months for this report. We found out about it 48 hours before we went to the city council workshop. So we had not had a chance to look at it, to digest it, to try to figure out what parts of it, which a bunch of it was very interesting. I agree with Mr. Lyon. It was interesting to read back about old civil service matters and the city's political dilemmas at 40 years ago, but it didn't address the fact that a charter had been passed that had the provisions in it that it has, that basically says the EEO policy of this city is determined by only one entity, the Civil Service Merit Board. So we were a little concerned that that wasn't maybe brought out at the level that we think it should have been discussed, because it's not discussed in the report in that context. So as we looked through and read the report and digested it as best we could, the historical stuff, again, very interesting about how dysfunctional some of the city government matters were back in the 80s. But that's what, 60 or 70% of the report was. What we tried to focus on, and what I was going to get with you about today, and Mr. Chairman, how we do that is what I want to address. when it's time to do so, because you've had a whole lot to digest in the last 18 days. I mean, we're being asked to review something in less than 18 days that the city's been getting outside council opinions on for 18 months.
That is not
So at the end of the day, one of the questions we had that is pressing for me is, if we're going to have to follow the guideline that's expected, the expected guideline, that was one of the questions I had today. It was presented to the workshop, the city council workshop, that in a matter of, I don't know, looks like when I'm adding it up, less than 3 weeks, that the city already has a plan to have the council consider code section revisions that we haven't even seen yet. What they're going to say, who's going to be doing what, when, and how. So one of the concerns we had was, and the city council told Dr. Drummond and told Mr. Lyon that, wait a minute, this is a fast turnaround here. And we'd like to have some time to at least read this report. So I'm not sure what they've been able to accomplish on that yet. But as far as hearing back from us, we wanted to report it to the board. So I advised Dr. Hatfield to be sure. And again, it's overwhelming when you go back through all the reports, because I looked back, and I think other than Dr. Lyons and Dr. Taylor, there was no one on this board other than those two that went through a workshop that we did in October of 21 on these issues when they first came up. So I thought it was fundamentally unfair for, Ms. Roberts, Mr. Dukes, and Mr. Schimmel to have to try to go back through all of this when they hadn't even seen a lot of it, probably hadn't looked at the minutes. So that's one reason you got all of this, which again was ambitious. It wasn't to overwhelm you, it was to show you that these issues are fundamentally important. They've been talked about for 2 years. I mean, the city council brought it up, wanted the city council resolution wanted the civil service and its director to be involved. So these were important matters. They were so important, we had a workshop. And then we produced a report and that you should have there in November 10th of 21 that went to the mayor. We asked to see the mayor's report to the city council before it went in. We didn't. The mayor's report was produced, and we didn't agree with everything, the recommendations in it. So we did another, we met and talked about it, and I did the comparison report. So there are 3 reports that some of you had probably never even seen before, didn't know anything about. Those reports are not specifically mentioned in Mr. Lyons' report at all. A lot of the code sections are mentioned because there are some matters that we had concerns about, the mayor and her law department had concerns about, Mr. Lyon has concerns about. There are matters that need to be addressed, and we pointed those out. My comparison report that Councilwoman Parker asked for, and that we produced, and that was given to City Council, was given to the board, was given to the mayor, was given to the law department. That's what, and it was my understanding, Mr. Lyon, I hope it was given to you, that comparison report.
Yes.
Because I had asked in our January 12th, 2022 board meeting, I went through, in the minutes of that board meeting, hopefully are available to this board to look at. I went through, and that's one reason I want to bring it up in this context, Mr. Chairman. I had been through an analysis of again, not having seen Mr. Lyons' report, not an analysis of his report, which I'm prepared to go through today in whatever detail we need to. But in fairness, to hear this and try to drink out of this hydrant today without going through this in some way that this board can put it in the right function, it will be very difficult, especially if there is going to be code sections. And that was the biggest concern, is that there were going to be code sections presented to City Council we haven't even seen yet. Now, it did concern us a little bit that as part of the city workshop agenda on August 31st, that there was one of the agenda items was that there was already a plan to implement this report to be presented at the workshop before the report was even produced, which led us to believe that perhaps there was already something out there, that there was a plan and we needed to see what it was and how quick it was going to be implemented. We found out at the workshop the timeline, which is at the end of the workshop, I think the PowerPoint presentation that Mr. Lyons made. With this coming before this board today, a first reading of an ordinance, September 19th, that's next week. We haven't seen the ordinances. And then going to a second reading, October the 3rd. Well, after the second reading, that would be law, it could become law. We haven't even seen those. So, and that was the thing I believe, and this is my interpretation, the city council members on the workshop said, wait a minute, it's a little quick to get into passing ordinances when we haven't even seen, we haven't had a chance to read this report yet. So that was our first concern that resulted in all of this, because I wanted to see how this board wanted me to function in this. I'm prepared to go through and tell you what to look at and where, and what I don't want to do is spend hours, which it would take hours. I'm prepared to do that today. I mentioned to Dr. Hatfield, perhaps we should have a workshop, another workshop where I present that, and we talk about it, especially if there are already ordinances that have been drafted that we need to look at and see too. That would be an important part, and how the city intends to go before the council to implement this plan when the Civil Service Merit Board hadn't really had a chance to digest it. The fact that it's being done so quickly was my biggest concern, is that will we, after all of this time, have time to really digest what we're looking at? So, I'll defer to the board on how you want me to present it, how you want it presented to you. I can go through and give you the short version now and respond to some of the things Dr. Lyons said. I mean, Devin, sorry.
I appreciate the promotion.
You know, well, you do have a JD, so you are, in Brazil, would be called doctors. Dr. Lyons, what I'd like to do is do whatever the board wants to help them effectively digest what they need to look at. Again, they need to look at all of it, and I hope you do look at all of it. It's overwhelming. Some of it is inconsistent. Some of it is stretched out over time. But at the end of the day, there are seminal matters that the board should focus on, because what we're basically talking about are charter functions that are, and as this report penultimately says, and this is the part that really concerns me, on page 58 of the report, and perhaps we can ask Mr. Lyon a question about it. In his recommendations, one of the portions that really got my attention was, and like I said, again, it's on his page 58, not packet page 64, okay? So that's what you should have in front of you. Some of the recommendations included, and Ms. Roberts mentioned the word streamlined. This statement is in this report. Quote, organizationally, city processes can be streamlined and simplified by routing all EEO and employment-related matters to the HR department for resolution. Unquote. What did you mean by that?
That's, exactly what I just said.
Okay.
That as HR serving as a clearinghouse, HR can then take whatever types of complaints come in, and if it's a complaint that HR has the jurisdiction to handle, investigate, resolve, it'll do that. If it's a complaint that, for example, the easiest example, is an allegation of discrimination in hiring, transfer, or promotion pursuant to Charter Section 1003 F8, then HR would resolve that complaint by kicking it to the merit board for additional action.
Who would be, and I'm reading on from that recommendation, and again, if this seems adversarial, it's not, I'm inquisitive right now, because the one thing that I recommended before, 2 years ago, in my reports, we should be focusing on what I call C words: cooperation, communication, coordination, competency, and not competition. We're not in competition with the city or the HR department for functions we're supposed to perform. The idea that and this is the takeaway that was bothersome to me, that matters that would normally be within our purview, the next sentence in this report says, from there. So in other words, everything that's EEO related is going to go to the HR department before we know about it. It says from there, should a matter invoke the Civil Service Merit Board's jurisdiction pursuant to city charter, which they can't get around, we all have to bend to the city charter, the HR department would be obligated by code to notify civil service. Who would be that person that would be deciding whether to notify us or not?
That would be the EEO officer that would ultimately be given supervisory authority over EEO complaints. And if it's a matter that is outside HR's jurisdiction, then that type of complaint would be referred to civil service. And I agree with you, Mr. Winchester. I think it is important to emphasize those C's in cooperation.
Right.
And I think that's this recommendation is a great example of that, by making it simple for employees to be able to have their concerns heard, and then effectuate cooperation between the merit board and the HR department, so that where those complaints invoke civil service jurisdiction, they are cooperatively immediately sent over to the board for further action and resolution, as required by charter.
Well, so the cooperation part and coordination didn't involve contacting us to review this before it went into print, or these recommendations were going to be made anyway, and then given to us on a short term?
I'll address that, because I was hoping to get a chance to say that based on your initial comments. And I'm not assuming that you meant this personally or directly,
No.
But to be fair, the city received this report at the same time as it went online. I delivered the report to the city on August 29th. A few hours later, I believe, I think it was actually hours, this report was online. So the city did not receive this report any faster than the Civil Service Merit Board, at least in terms of it being widely available for review. So we're all operating under this crunch timeline. And relative to the reports that Civil Service had previously prepared, or your memorandum that compared the Civil Service report to the mayor's report that was the city council, I think I already addressed that, but I just want to be clear. I did review those in the course of preparing these recommendations. And again, I understood the interpretation of certain charter and code provisions that had been set forth within that memorandum. But again, to ensure my independence from both sides, from both city administration and the Civil Service Merit Board, I did not reach out and initiate contact for that very reason, so that I could sit here today and tell you this is 100% what my recommendation is based on my interpretation of city charter, which is guided by all of that history that, you know, I understand you're saying that much of that was before a charter revision. I think much of that was actually after the charter revision, but I think that the timing of that history is objectively the best interpretation of what those charter provisions say, because that history is setting forth the drafters of Article 10, their perspectives on what powers and duties the board has and what powers and duties the board does not have. So that history is necessary in order to be able to establish, as I said earlier, the gutter guards that set the parameters by which the city can then take action to best effectuate EEO in light of what MTS has found with their benchmark survey results.
Well, let me respond by saying this. How could there be a plan then already prepared on a timeline to present if the city hadn't seen your report before it was presented? How did that happen, Mr. Lyons?
Well, and I can't, again, Mr. Winchester, my role in this process is to act as an independent consultant. I am not the policy guy in terms of implementing this report. I can make recommendations, which I have done, and I think to the point of not seeing an ordinance. I think the report speaks for itself in that regard, relative to what specific terms a potential ordinance or revision to code would look like. But regardless, that's not my role in this process. And so I'm happy for the city to.
Because I think there's one issue that I see hanging all over this, which I have to admit I don't understand. I think you spoke to it just a minute ago. Is there really an envisioned ordinance to be on the agenda of the September 19th meeting? And I will ask Mr. Shields that maybe because I can see you're an independent consultant. George, would you speak to that? We can't hear.
George, can't hear you.
Hear me now?
Oh, yes.
Okay, slight delay. I'm really not aware myself of that. The law department puts things on the agenda when we're told to put it on the agenda, but as many of you know, that's often a decision that's made by policymakers. I think if anybody's probably positioned at this time to speak to the schedule, it would have to be, one of those policymakers. And I'm not sure if maybe Dr. Drummond is in the room or somebody else who would be better positioned. We'll certainly put on the agenda what we're asked to, but I'm not sure what we're going to be
I
asked
haven't
to.
been gone from this place too long to know that the agenda for Tuesday would go out tomorrow.
That's right.
So, is there any?
I can address that.
Okay. Let's have Mr. Drummond address the agenda item.
I'm going to address two things that Mr. Winchester said. And the timeline, you asked the question, how could the timeline be there? We received the information, we had a long conversation, and we met, and before it went out to City Council, we created a timeline. We did that after the information came out. So it was not done prior to. There was nothing malicious, there was nothing done
No one suggested
to
that.
do that. But what I am going to tell you, we listened to what council said. We listened to the fact that we realized that this is a long document, and we heard that. You will not see a request on City Council on September 19th because we listened. We also wanted to bring this before you all. Based on this, we're hearing what you have to say. And so based on this conversation, the mayor and deputy director and the law director will make some decisions about when it needs to go to City Council, but it will not be on the agenda on September 19th.
Great. That was my biggest concern. And Mr. Lyon, you mentioned the crunch deadline. What was the deadline then that was crunched that you mentioned? What happened?
Well, if I said deadline, I didn't mean a deadline in that sense. Just in terms of the time period between receipt of report and City Council workshop was the same for all parties involved.
Well, I'm glad because my biggest concern, like I said, was we didn't have time to look at this, advise you, and go through it. We're asking a non-paid board to spend a lot of time doing things that the city had 18 months to do, and I thought we were going to be asked to make some decisions on a very short timeline because that's what's in the presentation, a very short timeline. So I'm glad, Dr. Drummond, thank you for clearing that up. That said, Mr. Chairman, I can go through and give you all my comments that I've been able to put together, or I can give you the seminal parts that I mentioned, and then we can either come back and go through it because you're going to have a lot of questions, and I'm glad to try to answer them. We have Mr. Lyon here. This would be a good time to ask those questions, but he hadn't heard my comments yet either. So how does the board prefer to do this?
Well, I want to make sure we kind of differentiate among all the parties. I mean, we've got the city law department. There's some, we don't know that they would follow all the recommendations. I mean,
I don't know. I haven't
we
heard
don't
from
know
them.
that.
No, I don't know.
So we're not quite sure what would be in any proposed ordinance, and also what role you know, what kind of, the board would instruct, I'm just trying to think, what kind of, who would be a spokesperson for what when that came up. I mean, there's a lot of this to try to get our arms around, as I see it. It is good to know that we're not under, you know,
That's a
super
big
emergency.
thing, yeah. I was ready to go a couple hours with you.
But I wanna, that's just me as one member, so I just opened it up to the board is, you wanna hear the whole thing and, you know, bring your sleeping bags and everything for later or right now? Because it seems like it'd be quite lengthy, or do we wanna hear the Seminole version, or do you want, what's the board's pleasure on this?
Mine is not like, oh, I'm sorry, go ahead.
If we're gonna hear the full version, I'm gonna ask Ms. Johnson to show me how the Keurig machine
Yeah.
works. Now, I would say that the Seminole version.
Yeah, exactly, and then I'd like to see your written report and have time to digest it before we come back.
Or do you want me to make a written report?
I would. I mean, just, you had said you had one or had.
No, I didn't.
I mean,
I've done a written report that I was going to mention to you, and again, those, Mr. Chairman, let me advise the board to do, this is what I would do, now that I know we don't have to do something in 2 weeks. I will go through right now, let me make some responses to what you've heard today, because you've heard it today, and what I will do, I will go through rather than 7 or 8 pages of notes, I will go through the parts that are, like Mr. Lyons said, the takeaways, that were, if I were looking in your position, I would go look at these things first, and then come back, perhaps either a board meeting, special meeting, workshop, whatever how you want to do it in the next few weeks, or even at the next meeting, and ask meaningful questions. Otherwise, we'll be doing this piecemeal. The reason I'm saying that, I'm glad to do whatever this board wants to do. But this will be the 3rd time some of this has been said and done, which again, not to all of you. You haven't seen it. So what I thought I would do is point out to you where in this pile of stuff I would start, recommend you read it all, but then let me tell you, and let me go ahead and make some responses to what Mr. Lyon has said.
Could I make one recommendation? Very good, let's set the standard.
All right.
See if we can do a written report.
yeah, but I wanted to like, the Reader's Digest version. I mean, this is a death by 1,000 cuts right here. So it was well done. I've had to hear this statement twice. So you're doing a great job.
How about we take about a 2-minute recess for purposes of personal relief? Okay, so I believe where we left it, is it at the sense of the board to hear the,
Really short.
The short version, okay, that would be.
Because, and again, I've answered questions too, of whatever we need to do, but let me say some things that, in response to, somewhat you heard from Mr. Lyon today. I've already asked about the enforcement matters, but, out of his report, so I won't go back through that again. The historical background, I'm not going to go through it all because I think some of it, while interesting, I was practicing law during those days. I was not connected to this board, but I was in the political milieu of what was going on during the World's Fair and what else was going on. And the idea that 34,000 voters, when you compare to this last vote, 16,000 voted. 34,000 voters voted that week and passed, or in 1981, correct me if I'm wrong, Mr. Lyon, and by a narrow margin, passed the charter provisions that are Article 10 of our charter. Our charter is the enabling legislation. Would that be a correct statement?
That's correct.
It's the Constitution for our city. Nothing, it's like our U.S. Constitution. It controls government, what government can and cannot do, and who can do things. And the reason that's really important is because the city can't pass code sections that are inconsistent with it. We can't take actions inconsistent with it. We can't pass rules inconsistent with it. It goes back to what the voters in the referendum wanted. Now, for whatever reasons, discord, a World's Fair, city government, the voters passed this charter and these provisions, and we have to either change it or live with it. let me tell you the really important parts of the of Article 10 to look at, and some other charter provisions that are important in the context of what we're talking about. First of all, there are no charter provisions that I can find that deal with who can make EEO policy, Equal Employment Opportunity Policy, which is under Title 7 of the federal laws, which deals with employment, not Title 6, which is part of what your package is, that I'm going to mention here in a minute, where the mayor, by charter amendment, under Section N of 303, I believe, if I'm correct on that, has under Title 7, under Title 6, let me tell you what Title 6 is if some of you don't know. Dr. Drummond's here, and others are here, correct me if I'm wrong. That deals with federally assisted programs and how that money and you would know this, and perhaps others that deal with it. The federal government says, here's some money, but we're going to tell you how to use it, kind of, sort of, and directs. And if it goes into if it goes into employment, then under the charter provisions for the powers of the mayor would have specific authority to do things under Title 7, under employment, that's not in the charter. The only place in the charter, ladies and gentlemen of this board, where there's any reference to EEO is in charter section. It's under our powers. And if you don't know these powers, you need to read them. I'm sure you have. I can imagine that after all of this, that isn't something that each member of this board focused on. Under charter section 1003, capital F in parentheses, it says powers and duties of the Civil Service Board shall be as follows. The most important one in here for this discussion is 11. To develop a program to provide for equal employment opportunities to all employees and applicants for employment with regard to all aspects of employment. Now think about that. All aspects of employment. We're not just talking certain things. We're not just talking, if there's to develop a program, there is no other power given to anyone else by charter to develop a program for equal employment opportunities except this board. Period. All right, Dr. Drummond? Kevin?
No.
Well, I didn't think you would agree. But I had to ask you. And what's even more important is that another part of the charter says this. And it's not mentioned, I think it may be mentioned in at least one report. The charter says, the city of Knoxville, this is section 231, which is in my comparison, one of my comparison reports. So what I'm doing is telling you I'm going to tell you where you can find these things, but I'm hitting the high points here on charter provisions. It says the city of Knoxville shall have the power to create, alter, abolish by ordinance departments, boards, commissions, offices, and agencies, and confer upon the same the necessary and appropriate authority for carrying out all their powers, including the promulgation of rules and regulations or codes. But when any power is vested by this charter in any specific officer, board, that would be you, commission, or any other agency, the same shall be deemed to have, that would be your board, exclusive jurisdiction within that particular field. This board has exclusive jurisdiction within the EEO field, Equal Employment Opportunities, because no one else has that power. And if they do, it's only tangential, and it's not by direct power given under the charter. Now, Mr. Lyon made a comment that we don't have the right to enforce our own powers. Cannot be more fundamentally wrong, and I respectfully say that, because the charter itself also says, and you need to see this,
Before you move on, it seems to be a sticking point, what I heard, Mr. Lyons, is to develop a program. It seems like that word wasn't the same thing as have a program that has enforcement, or.
We're getting to that.
Yes, sir.
And I'm going to tell you that, first of all, enforcement of our EEO policies is not just a function of this board, it's a function of everybody that works for this city. Everyone is responsible for complying with, and there are code sections that Mr. Lyon mentioned that I'm going to get into, where the city council recognized that there are some overlapping situations where both the mayor and the board need to be involved in certain things. And I'm going to get to those as part of the highlights here in a second. Okay. The charter goes on to say, under your Article 10, it says this. Let me get down to it. If you would look at Section 1003G of the charter, Civil Service Merit Board rules. Let me stop right there for a second before I get into that. The charter preparers, drafters, they understood this was going to be a civilian board. You weren't going to get paid for what you were doing. You were going to have to act through a civil service board that had agents working for you, including a executive director, civil service director, that was going to have to enforce what you wanted them to do. And I also use the word enforce because if you will look at 1003G, Civil Service Merit Board rules. After a public hearing, the board shall specify rules as to the conduct of, and there's a laundry list, investigations, like discrimination investigations, hearings, the exemption of positions, eligibility promotion list, examinations, procedures, employee appeals of disciplinary action, and such other matters as are necessary for the execution of its powers and duties. In other words, you could pass rules and regulations, which you have done over the past 40 years, 50 years, to implement these powers. In other words, for instance, to hear or designate hearing examiners and to hear allegations of any persons, these are powers you have under 1003F4 to make investigations, 8 to hear allegations, 6 to hear disciplinary actions. They didn't expect you to do all of that in person. You could promulgate rules and regulations to enforce your powers. And that's what you've done. To say that this board doesn't have the power to enforce its own powers and duties is just wrong. It's just wrong. And on top of that, if you will look at and again, I'm in the charter, I'm in our Constitution, 1003D, our executive secretary. If you look at that, it says what her duties are, duties that by charter to record the proceedings, render such assistance to the board as may be required. This board has by rule and regulation said our executive secretary is going to assist us in certain ways. You put her in a position to do that by your articles and your rules, to sit in and do things. She has powers because you've given them to her. And one of the glowing examples of it is what Mr. Lyon just mentioned in his report. This board, promulgating sections 301, 302, 303 about what the city can do and not do in certain situations, is one of those rules and regulations that they're using to say, oh, well, only we can enforce and do certain things, and we can establish things. But he didn't read on that says, this plan under section 302 of your board rules, any plan for affirmative action shall be, it says, this plan shall be consistent with section 1003F11 of the city charter, which states the board has the power and duty to develop a program to provide for equal employment opportunities to all employees and applicants for employment with regard to all aspects of employment. The city council, and again, these are similar things you need to look at. He mentioned these code sections. The city council, when they were looking at how do we adopt code sections, which are just statutes like Congress enacts laws. These are the laws the city code is enacted, the city council has enacted. The city council in their article or in their section 2.2-3, duties of the mayor, have said under section 1, under duties, that it shall be the duty of the mayor to appoint competent, qualified officers and employees to the administrative service, and the mayor shall have the power to dismiss, suspend, and discipline in accordance with, that means pursuant to and consistent with, the charter, the city code and ordinances, the civil service and personnel system, and the civil service merit board rules and regulations. The mayor is controlled by our rules and regulations and has to act consistently on certain matters, especially if it involves employment under Title VII. That's the first bailiwick for power for Article or Title VII, employment rights for EEO, is invested in this board by charter. It goes on and says this under, these are code sections again, 2-3, sub 1, that means 1's in parentheses, small j. Employment, equal employment, and affirmative action. That's where we are. That's what we're talking about. The mayor, in conjunction with the Civil Service Merit Board, will issue an employment, equal employment, and affirmative action policy and carry out the city's plans to provide equal employment and affirmative action in all employment practices. Let me stop right there, because that's one of the C words I was talking about earlier. What the city council did, and what we should all be doing, is say, well, wait a minute. For the mayor is in a position, and the mayor is required by law. I'm not telling the mayor what to do. He's got good lawyers. And y'all hopefully have good lawyers. Mr. Lyons, good lawyer. We're all trying to get to the same point. What's in the best interest of this city and its employees? That's what we're all here for. The city council recognized that the mayor is the one in his administration, and that's a key word, administration. There's one thing to say you have power to develop a policy. There's another one that says you have the power to carry it out and enforce it. But by rules and regulations, you can do that for your powers and duties. And what the city council did by enacting that statute was say, you know, both the mayor and the board are in charge of these type of matters for EEO and affirmative action, and they should do that in conjunction with each other, not in competition or in opposition to each other. We shouldn't be carved away from it, and we're not. I don't think we can be. And our rules and regulations are part of that. Now, I think that's also why, and it's my opinion, it was in my earlier reports. And that's the seminal things I'm going to talk about now. There's a lot of detail that I'm going to leave out for now unless you ask a question about it. Everything I'm saying right now is either in the first report, which is the Civil Service Report of 11/10/21. It went to the mayor, it went to the law department. Then the mayor's report came out. Then we did a comparison report. You should have and it was dated 1/5/22, if memory serves, and it was presented to this board 1/12/22. The board minutes, I don't know, do they have the board minutes? 1/12/22?
They should.
Well, we should have it. We should have it.
Provide them.
I went through the chairman may remember it, Dr. Taylor may remember it, I went through an hour of comparing the mayor's, what I'll call the mayor's first report, because I look at I looked at what Mr. Lyons produced is either part of that or or a part two of it. The mayor's, this is what the mayor recommended to the city council. Here's what we recommended. City council, Woman Parker asked for a comparison. This board authorized me to do a comparison report, and I did that and presented it. I would say that's one of those things that will cut through a whole lot of this, as far as my background and what I'm going through now. Look at that comparison report as one of the ways maybe to get back into reading much of what we're talking about here today. Because, and it's in our minutes of January the 12th, where I went through a lot of detail again. And again, it took an hour or so. So those two reports are, I think, important to get you into some of these code sections. But the other part of what we're talking about here today is the administration and management, which the charter, Article 10, specifically says in several places. And I'm just going to tell you where to look on that. First of all, if you look at F, our powers under 1003 F1, and this is the most important provision, that's why they put it first. That's the way governments usually do it. To represent the public interest with regard to merit system principles in the management and administration of the personnel systems of the city. We're supposed to be involved and represent the public interest. That's your duty. In the management and administration of the personnel systems of the city. That's all of it. HR, that's everything. We're supposed to be involved in the personnel systems if it involves employment. And not just making policy. Y'all know what the words management and administration mean. The number 3 power, 1000, again, these are the ones I want you to focus on because you need to digest them and see if you really believe that what the city's recommending is what you ought to do. Under 1003 F3, to advise the mayor, the directors, the Knoxville Utility Board, and council on matters concerning personnel administration. We're supposed to be doing what we're doing right now. Telling them and advising them. They don't have to take our advice. 1003 F4, to make any investigation which it deems necessary concerning the administration of personnel. Administration of personnel. That's what the mayor has administrative powers. You do too. You have those powers given to you, but you can enact by rules and regulations. That's what you've done. The administrative personnel under the authority of this charter. It says we can put people under oath, by subpoena, we can require attendance and the production of documents to make investigations. That's one of the things that was a key, I guess, piece of the act of the competition was who was going to make the investigations. That was really one of the reasons that Councilwoman Parker asked the questions she did. Who's doing these investigations? How are they being done? Who's keeping up with it? Both the reports, and I recommend you read both our civil service report and the mayor's report, because we both focus on investigations. Those are important things for this board to look at and for the city to look at, to ask the city council to look at and address, because people are concerned about the investigations. But let me make one thing clear. We've been given specific power under the charter to make investigations about administration of personnel. By charter, that can't be changed by city council rule. It can't be changed by the HR department coming back into existence. Just because the HR department is back doesn't mean that they should be in charge. They should have all of this funneled through them, because the charter that's been adopted by a small majority, but by the citizens of this city, says they want us to do that. They want you to do it.
Let me ask you this question there. Would you read that? It says make recommendations,
We can advise, well,
which is, I mean, recommending and advising is not the same.
where did I say
I
recommendation?
thought I heard you say.
No, I didn't, in this,
Okay.
in these, in this. It says we can represent the public in the management and administration of this, of the personnel matters. We can advise, I did say the word advise, the mayor, that's in power F3 on matters concerning personnel, again, personnel administration. I'm on 4 now, to make any investigation concerning the administration of personnel under authority of the charter. I'm going down now to, and again, this is the powers, and you should look at all of our powers, but then 1003 F8, to hear allegations on matters of discrimination. Sexual harassment is discrimination. Under federal law, state law, in employment, discrimination in employment. In hiring, transfer, or promotion, the part that I didn't hear a while ago, which is included in your powers, it's not just hiring, transfer, or promotion. It includes neglect of duty. That means the city isn't doing something they're supposed to be doing. Somebody's not. Or other violations of merit system principles as established by charter. How do you hear those allegations? Do you have to bring them in here in a board meeting? Of course not. They can do that. But you pass rules and regulations that say how those allegations should be brought before the board or the people authorized by the board to hear them, including this executive secretary right here. To say that she doesn't have power to do some of these things or all of these things, it's just wrong, in my opinion, because the charter says we can do it. And then, of course, the last, and again, you can, you should read them all, but then under F11, that's the one about developing a program. So we're involved in the management of an administration of personnel matters before that involve personnel for this city. It involves employment, and you can do that by 1003G. I've already told you that you need to read that, because if we promulgate a rule to enforce our powers and as you deem necessary for the execution of your powers, that means it's totally up to you as you deem necessary. And we have case law that says that when we have powers that say to promulgate rules is as it deems necessary, they do have to be consistent with our general laws and constitution, but it's up to you. You have discretion on how you do that. You've done that. So those are from the charter standpoint, and then also, I would tell you, you need to read Charter Section 1008, which obviously is important. It's entitled Personnel Administration. And I'm reading from it. Personnel programs, policies, and procedures of the City of Knoxville, that's what we're talking about, shall be administered consistent with state and federal laws and the charter and the ordinance of the city, and shall include but not be limited to, and then they list a laundry list of things, including human resources, salary, wages, benefits, and record keeping, training. They go employee complaints. So the city the charter has said the city is involved in many of these same things that the Civil Service Merit Board is involved in. That's why it has to be in conjunction with us. The charter has said you all need to work together on these things. Mr. Ryan is right. The civil service charter for this city is unique in a lot of ways. When I do research, if we get in litigation, which is rare over these issues, you have to look to Memphis, or you have to look to some other place to find law on it, because they do it a slightly different way, but they don't have this charter And these requirements written like this, we do, and we have to honor them because the citizens of this city are the ones who put this on in the record. It said do it this way. The fact that the city and the civil service were fighting 40 years ago about this is interesting. I was interested in it. I was here while that was going on. Not with this board. But the citizens said, do it this way. We're all bound by it, and we should be. Now, I think that's why that provision, and again, these are provisions under not only some administrative rules, but if you look at the city council's code sections that deal with this enforcing officer, and again, that's been prominently mentioned. There's a reason, and I've gone through about 30 minutes of reasons. Under section 15-53, enforcing officer generally. That's the part that Mr. Lyon read about. The mayor is to carry out the functions and purposes of this division. In other words, the mayor is a principal, if not the principal enforcement officer. I agree 100%. Should be. The enforcing officer by the city code has responsibility for carrying out and enforcing the provisions of this division, which are provisions that deal with employment. That's our bailiwick, Mr. Chairman, under Title VII. Not the mayor's, that's ours. Employment under Title VII, not under Title VI functions of the mayor. Shall be placed with the person designated by the mayor to carry out the functions and purposes of this division, who shall be an appointed member of the Civil Service Board staff. And the city council was recognizing that the civil service could appoint somebody to be part of this process of enforcement. That's why it's written that way. It wasn't by accident. They didn't mess up. They said it this way on purpose because that's what the charter says that this board can do, and because this board has the powers to take that action, broad action, to develop a program. A program means, if you look up that word in the dictionary, a system of policies and procedures. That's what a program is. We have the power to develop a program for equal opportunity in all aspects. And how do y'all interpret that? If you were on a jury, how would you interpret that?
So if this board here has the power to develop an EEO program, correct?
Mm-hmm.
Can I not delegate which department covers that
Yes.
program?
In my opinion, you could, yes.
So basically what we're going all the way back to, and this is all, keeping all the C's cooperating here, I don't want to strip any powers away from civil service merit, executive secretary, any format of that nature. But I just think we need some more time here
To look at
to,
it.
as a board, to look at everything within that. But it is my professional opinion as an HR professional, and I was put on this board because of that reason. These streamlining effects, I do believe make sense. And I get the charter. I understand it's our little constitution to follow, but we also have amendments to the Constitution, right? And that's something that gets voted on by, what we mentioned, the public later on if we needed to.
That's right.
I'm going way down that path. So, but if we have our own power within this board right now to approve of some of these EEO program changes to different personnel in different departments, aren't we able to do that?
Yes.
Okay. So,
You can do it.
okay.
City council can't do it. When you say delegate your powers, you can pass a rule, regulation, or procedure and say how to do things involving the powers that are in your exclusive jurisdiction. Because that's what the charter says. I just read the provisions.
Hypothetically, what are limits on, you were referencing delegation.
Sure.
Or you're not doing
If,
it.
if we create, if we have that power to create,
Right.
then we can delegate who within our system here can administer that.
So how broad is that delegation?
Uh,
Could we delegate it back to the HR department?
Yes.
If we wanted to?
I think you could, because the HR department had, the HR department would only have those powers earlier if they had those powers under the charter. See that the charter didn't come, this provision of the charter didn't come into 81, if I recall.
And let me, if I may, I've been quiet over here for a while, so let me jump in just to say, to put your minds at ease about the charter interpretation issue. I am fortunate, and let me clarify, that this report that you have is not a city report. It is not they or them versus the Civil Service Merit Board, right? What you're reading is me. This is my recommendation and my interpretation. But I have a benefit in that I don't have to put my neck out and say, well, I'm going to look at these two provisions over here and connect them to these three from the code and look upside down and sideways, and this is what I'm saying this means. I don't have to do that. I'm not telling you what the charter means. I'm including the history of what the drafters of the charter say that this means. We don't have to go through all these hoops. And I hate to hear that the time and effort and copious attention to detail that went into this historical section of the report is apparently being glossed over, because that answers the question. It tells you directly and over again that the actual authors of Article 10 never designed the Civil Service Merit Board to have enforcement authority. The easiest example of that is it's Appendix 46. There's a memo from John Roach, the law director at the time, who served as the chair of the Charter Revision Commission that promulgated Article 10. When asked directly from the Civil Service Merit Board, does the board have enforcement authority over affirmative action goals and other types of EEO functionality for the city of Knoxville? And the answer was not just no by Law Director Roach. It was no by Staff Attorney Charlie Sturkey, who was at that time the attorney who represented the Civil Service Merit Board and the only attorney who represented the board. Their uniform opinion was not just no, there's no enforcement authority, but they went through painstakingly and examined each of these 12 underlying powers within 1003F and said no in relation to each of those individual powers. No, the board does not have enforcement authority beyond the plain language of F8, where they can hear allegations of discrimination on matters of hiring, transfer, and promotion, but nothing beyond that. And the key point here, F11, the power to develop, their conclusion, again, as authors of Article 10, was that the board does not have enforcement authority through its development authority. That's not just their opinion. That was their chosen verbiage based on what had previously been suggested by the City Employees League in their initial draft of Article 10, which was to include the language "provide for." That language was changed by the drafters of Article 10 to soften it, to develop, for that very reason, to ensure that while development authority may lie with the board in some capacity, any enforcement thereof must remain with the city mayor. And I think it's interesting, just as an example here. Again, one of the processes that I struggled with in going through this report. Let's assume, for just hypothetically, that the charter did give the board the power to investigate any allegation whatsoever, or it did give the board the authority to hear any allegation of discrimination whatsoever, unbridled authority. The system we currently have in place is one where I'm an employee of the city, and I believe I've been harassed in some way. I'm going to go to the civil service director and file my complaint. The civil service director is then going to take my complaint and investigate the complaint, come up with the director's summary of findings and recommendations that are then given to the mayor, given to the director of law, and given to the department head of the affected employee or employees. With that information, the department head may then take disciplinary action. So, at the recommendation of the civil service director, a department head has taken disciplinary action for a sexual harassment violation. What is the recourse that that employee has as someone who has been disciplined? Well, under the charter, the board can hear, not just appoint a hearing officer, but can hear an appeal of disciplinary action. So the problem that the charter drafters understood with conflating the enforcement power with the development power is we've now created a system where the merit board effectively serves as judge and jury and neuters the appellate ability of any employee to feel that they have had a fair shake of an appeal. Am I going to think if I've been disciplined for sexual harassment following an investigation by the civil service director that I have a better shot of appealing that to the board and getting a different outcome? No. The board is serving as judge and jury in that setting. Whereas if the enforcement authority is separated, as the charter drafters tell us it is, we don't have that problem. You have a harassment complaint that is funneled through HR, if that's the appropriate jurisdiction, or law. There's an investigation, and a decision is made. And then, if there's an appeal, that appeal can come before the board or come before a hearing officer of the board in a more independent role, which I think any employee would tell you is their perception of what the design of the civil service system is intended to effectuate. But again, I think that we're hearing a lot, and I think that, you know, to the extent you all want time to digest it, I totally understand. This clearly took me a long time to get through. I think you should have the decency of having a little bit more time. But don't gloss over the history, because the history, we don't have to guess. We don't have to suspect and connect the dots. We know the answer to who has enforcement authority, and the drafters tell us that.
But do we know what the voters voted for? I mean, they didn't have that information when they had that vote.
Well, they did have that. I think they did have that information.
I mean, the drafters said this is what this is supposed to mean when they went to vote?
The Charter Review Commission was a public meeting that discussed these issues. The members who sat on the Charter Review Commission were repeatedly called upon, maybe in a different capacity, but again in public meetings, just like we're here today. And I mean, again, look at section 2 of the report. I can go through it if you want, but I don't think we want that.
That'd be
but
awesome.
it's littered with examples of the attorneys who drafted that language, advising the board there's no enforcement authority.
Back to the point that you could just, re-reviewed with us. That is my whole understanding and 30,000-foot view of where I want to come into play here. I in no means want to diminish any powers of anyone that works within civil service, serves on the board within that. But there has to be, I think that's what, when I came into this role, understanding about the new Human Resources Department being established and also having civil service merit. I think both are very valuable to the city employees. So I think both need to be here with checks and balances. And I think that's exactly what the board can support, at least on the civil service side, right? But I don't want anyone to take what I'm saying as recommendations on looking at additional comments on streamlining. Frankly, best practices here is a lot of all these EEO focused things need to be just housed within HR. I'm not saying I'm going to be the only person that's going to make that decision. I think it should have additional input. I do not want that to be misconstrued that I don't think civil service has any say in that at all. I think that my opinion coming outside looking in is, for the employees, I think it is best to have these separate functions that they can go to report issues through the proper chain of commands within the HR realm, and again, have civil service oversee the rendering. So that's another check to make sure that we are serving the city of Knoxville employees correctly and trying to eliminate as much bias as possible just through a one siloed system. So there are two systems here. We have HR here and we also have civil service, and I love that, okay? And I think that for the employee's sake, using it that way, having a more streamlined place for them to know who is handling my complaint that is affecting my day-to-day job, who is going to resolve that. If I have an issue within that, if I don't like what HR has to say to that, or my manager, who can I go to above all of that? And I think that's more where the Civil Service Board should be kicked in to, again, address and review that.
And let me just piggyback on that too and clarify. I hope I've already made this point, but just to be abundantly clear. Intentional. There is nothing in my report that invokes, changes, affects, limits, removes any power and duty of the Civil Service Merit Board. Those are to Mr. Winchester's point, those are contained in our foundational governing document. They cannot be changed. And none of these recommendations that I have made change these at all. They are, as you said, designed to streamline the process, to make it simpler and clearer for employees to actually have their needs heard and met, consistent with what every other governmental entity that MTAS survey is currently doing.
I would just like to correct something. One thing that I found frustrating is that as the person who has done these, no one has asked how they're actually done. You're taking information from other people who don't really know, they don't have firsthand knowledge. Something that Devin communicated as a reason to do this was not correct, so I want to make sure that it's clarified so that you're making your decisions based on accurate information.
We're not making any decisions.
Well, when they do. When a complaint comes to civil service and we investigate it, we do not make disciplinary recommendations. That was a legal opinion issued by Mr. Winchester some 20 years ago. We do not make disciplinary recommendations for exactly the reason that Devin just stated. We prepare a summary of facts. I do that with an attorney from the law department that serves as a co-investigator. We do every investigation together, myself and someone from the law department. Together, we draft a summary of facts, and that's all we do. We do not make disciplinary recommendations because that would then make us part of the disciplinary process, which we can't be because we are the appeal. That goes to the mayor, the department head, and the law director so that they may make disciplinary recommendations. I think it's important to know that it's actually how that works.
And that's in Article 17 of the rules and regulations you promulgated at my request.
And let me say this, if I may. That statement is not coming from a position of inexperience. As many of you may know, I was formerly an attorney within the city law department. And in that capacity, I actually worked with Director Hatfield on those very investigations. And I've got one of them that we signed, that Dr. Hatfield signed in 2015, that directly makes recommendations relative to policy violations on the part of a particular employee. And to the extent the report itself never went into the detail of this employee should be suspended or this employee should be terminated, that information was made very apparent in verbal conferences of which I was a party after the fact. So, I mean, I respectfully disagree, Dr. Hatfield. As someone who has been in those positions, that is exactly what happens. And the risk is there, one way or the other. And that risk is never broached if those processes are kept completely separate as originally intended.
Let me jump in here, take the pride of the chair. I mean, it's been here quite a while, and I'm trying to think what potential decisions we would be engaged in as a board and when, and so we can kind of look toward that. I mean, right now, there are no proposed ordinances. We all take a sigh of relief that nothing's coming up immediately. But I think at some point, once something is there, and correct me, any of the attorneys or anybody who disagrees, that we would then say, okay, taking a look at the ordinances, A, do we find anything we need at the board to make comment, because city council would be considering these when they make their consideration to make a recommendation? And B, depending on, we may need to take some action ourselves as a board to help implement whatever these recommendations are that would potentially be there in terms of our rules and procedures or potential delegation, as Jane referenced, if that was required. But until then, you know, I mean, I've heard a tremendous amount. I would like to go back and not only read the charter, read more carefully. I've done a Evelyn Woods, you remember that whole thing, you know, quick read of everything we've seen as much as I can. But now that I've heard all of the comments from everybody, I'm in a position to go back and look at this again and come and make some sense of it. But then, right now, it sounds to me like we need to wait and see what it is we're responding to and make sure, and I'm glad you pointed this out, Devin. I mean, you're making a report as a consultant, you're not representing the city, and you're not preparing an ordinance.
Correct.
You know, so let's kind of wait, and thank God we have a little time.
Well, I'm glad we have the time. That's a key thing.
Right.
That's important. But let me just cut to the chase. I've gone through most of the Seminole stuff because I think you have all you need to read really in front of you on these issues. And Mr. Ryan, you did a good job going back through all that. Okay, whether I agree with it or not, because that was a lot of work. Yeah, but let me say this, and this is what I said before. This is what I said during our HR struggles years ago. If the city's going to pass ordinances that deal with matters that we are, by charter, so intricately involved in, which we clearly are. I don't care what the lawyers said in 1980. You can't read the language in this charter and come to a conclusion that we are not to be involved in the administration and management of personnel matters, either by advising, taking action through rules and regs, or by passing our own rules. And I'll say this, if the city's going to come up with, and this is the big concern I had the other day with Dr. Hatfield, if they've already got ordinances in mind on the cooperation, coordination, why don't they come to us with those, and let's talk about them before we get adversarial about it. That would be good.
Well, I'm going to make the assumption of good faith that nobody has got any ordinances prepared and ready to roll yet, and that there should be, I would ask that there would be consultation and preparation of those. But, you know, and you kind of go from there for today.
I just like it. We just need to, it's a lot. We need to read. If we can go ahead and just stop one thing and look.
Okay.
Another thing, I mean, I don't know where our KPD or the fire department reps here are not here today or online. This is a lot of information too. And I know with our general employee reps, I would like to hear their comments regarding any, proposed changes that have been addressed, reviews and our changes. Suggestions today, because before we go even farther belaboring this point, I would like to have more of typical employees of the city's input into this as to how they would like to proceed. Because ultimately, this is his effects, so.
I think Larry McAfee is one employee rep and he's online.
Okay. Hi, Larry. Up there. But just back to that, I mean, at the end of the day, this affects the employees of the city, so I would like to have more input from them coming into future meetings.
So can we have the sense of the board, we don't have a voting item, that as this goes on, we would like, A, have time to digest all of this and reflect on everything we've heard today, and B, get input from employee representatives, and then have hopefully some advance notice of any pending ordinance in time to do some of these things. I think that's
Mr. Chairman, I mentioned workshop or special session. Is that something the board would like to consider? And just focus on just these issues? Because this is a lot to add into any agenda. And I'm just throwing that out because that's one reason you might want to do it. That way the employees, and that's what the city did with the city council, was have a workshop to introduce it. And the city council wanted to have more time, but at least there was a forum there for people that knew about it. And the city employees might, I don't know, I'd like to hear what the board has to say about the workshop.
Yeah.
I couldn't think of a workshop at this time.
Any other, just see who else wants to hear.
Just to clarify, I want to stay straight with all our rules, right? So the workshop is open to everybody. I'm for that, because that gives us more time, and again.
We can't make any decisions there,
Sure.
we just listen.
But it makes more time, I feel, for employees to make sure they're getting involved and
Well, that's why, because it addresses your point. And that's one way to do it. Now, again, the employees can come here to a regular session, but the workshop would be designed just for that purpose.
And if I may, this is, tell me to hush, Chair, if I'm out of line here. But just wearing my general attorney hat, I'm confused a little bit about what the purpose of the workshop would be. As you noted, this is not a voting matter for the board. I don't know what would be a voting matter for the board as this currently sits. Assuming, like you said, assuming the city ends up adopting any of these recommendations from the report and drafting an ordinance and sitting it before city council, that's a city council matter. I don't know what role the board would really have in that. And I guess my only concern from that point, in the spirit of looking out for the employees of the city of Knoxville, I wouldn't want the board to unintentionally give the perception of, we want to hear what your concerns are, we're going to address those concerns, but then the board doesn't have the power to do that because this is going before city council. So if anything, it strikes me like if there are concerns or if there is input from city employees, city council would be the venue to take up that issue if employees so chose.
City council can appear at our workshop. So at the end of the day, see, I don't really understand that. I don't understand that procedure at all. The people are going to be most affected by it, we want to hear from. If the city takes a position and seeks ordinances that hinge upon if that's the position of our board, if the board doesn't want to pass a rule or reg and say, yeah, go ahead and do that because we think it does, then it would be within our province to say we don't want, that we have problems with that. Why not find out? Of course, what I'd like to see is what these ordinances are going to look like. Because what I read from in your page 58 was all EEO matters and work-related matters are going to go to the HR, and then somebody in HR is going to decide what comes back to us. If I was on this board, I would be concerned and want to know who's in charge, who's the gatekeeper to decide what we see if we're not going to be able to do it. Because I just read from you those charter provisions that says we can be involved in both advising and participating in administration and management of compensation and employment matters. And that's what we're doing. I don't think we, to say we're not giving that up by what you're recommending, I think it's not correct. It's not correct.
I'm just saying that this board has no power to pass an ordinance.
Absolutely right. But we have a power to have input on it.
We have time from the next meeting to digest what we have here, because we need time to look at this.
Right, just to clarify one thing, I think when council considers an ordinance, they may want to hear input from board.
They said that the other day.
That's right. Now, and that I think we would give some instruction as a board as to what, under the charter, who is the spokesman for the board?
You are.
Okay.
Well, it's under Civil Service Merit Board rules. The chair is
The chair is, okay.
You are it.
So I think, you know, we want to make sure, and if I'm the one who is designated to be the spokesperson, I want to be the spokesperson for the sense of the board. So we're going to have to know that. And that, I think I'm beginning to agree with Taylor that maybe we should, I think it's premature to schedule a workshop myself right now. And I also would be hopeful that we don't have any ordinances being put on the agenda immediately. I don't know that there's any emergency, so I would make that request to anybody, city, that whoever, because no ordinances appear, there's a process for that. So that we can have another meeting at the next meeting and then we can have them digest this, and maybe we can then take this up again for Scott.
Well, I was just saying, because I think it could be premature to have that meeting if we had to have another one after the ordinance no more discussed,
Yes.
so.
Right. A lot of this is dependent, if there is a proposed ordinance even if somebody on council will say, all right, now I'm gonna move to delay it for X time, and then we could have whatever process we needed, including the board. But that would be, to me, a better way of having it than being presumptuous of what something might be in an ordinance and talking all around this, and then having an ordinance come out. I mean, that just seems to me, and I think the only reason we got into the mode we are today was partially because of that schedule. I think that's.
Absolutely.
So I think now that we can back up from that and say, let's just kind of put all of that on a little slower track, then we can then maybe take this up again as an agenda item at the next meeting and see where we are after everybody's looked at everything. Then decide as an agenda item, what are next steps? That might be a discussion, which could be, that could include a workshop or a decision that we would have a workshop pending an ordinance and a request that there be time for us as a board to then consider what next steps are. And if I'm definitely to get a sense of the board of a position on this matter. I think that would be what would be implied to me by all of this. Okay, well, I'll entertain a motion to adjourn.
I'll make the motion.
Do we have a second?
Second.
You want to? I don't want to force the ending.
Oh, sorry.
Go ahead.
Yes,
Okay.
motion.
All those in favor of adjourning, please indicate by saying aye.
Aye.
Opposed, none. Rarely enough. Thanks, everybody.
Thanks.
Thank you, Devin. Thank you, Mr. Winchester. This has all been very, everybody's done a lot of work.
Yes.